Second, I know we'll get questions about recording. We will be recording this webinar. The recording will be available on our website, texasrealestate.com, on the events tab, and also will be in the follow-up email after the conclusion of today's webinar. So if you missed anything, you want to go back and listen, you'll have that ability. Finally, questions. If you have questions, go ahead and type those in as they come to you. We will try to get all of your questions answered. So we are very lucky today to be joined by Chalisa Warren. Chalisa joined the Texas Workforce Commission Civil Rights Division back in March 2015 as the Housing Investigation Supervisor, and she is responsible for the supervision of 4 housing investigators. Before joining the Texas Workforce Commission, she worked with the City of Dallas Fair Housing Office, and she worked as a fair housing investigator and was eventually promoted to the Senior Public Information Representative. In that capacity, she was responsible for coordinating and conducting fair housing training and outreach within the City of Dallas. She earned her bachelor's degree in political science from Xavier University in Louisiana, and she later earned her JD from John Marshall Law School in Atlanta, Georgia. We are so pleased to have you here with us today, Chalisa. I'm going to turn it over to you. Thank you.
Thank you so much, Abby. I appreciate it. Good morning. Thank you all for having me. I really do appreciate it. As she stated, if you have any questions, those questions will be relayed to me. If I am unable to provide you with an answer, I don't have a problem right away. I don't have a problem leaving my contact information, following up with any information so that if I'm unsure about something, I can get you an answer that is suitable to your situation. So let's go ahead and get started. This is a presentation, obviously, as she stated, by the Texas Workforce Commission. Our division is the Civil Rights Division, and this is, today we will specifically talk about reasonable accommodations as it relates to assistance animals. So one of the things that I would like to share is our mission and vision of the Civil Rights Division, the CRD. Our mission is to reduce discrimination in employment. We investigate employment and housing discrimination in our office, and we attempt to do that through education and enforcement of state and federal laws. Our vision is to help create an environment in which the citizens of Texas may pursue and enjoy the benefits of employment and housing and also be free of discrimination. This is today's agenda. Talked about the objectives, what the purpose of the Fair Housing Act and the Texas Fair Housing Act is. We'll talk about what the protected classes are. We'll go through some things on the reasonable accommodation requests and service animals. Talk about our internal complaint procedure, what happens when someone files a complaint. And the latest information that I have are fiscal year 2016 trends. If anyone wants any updated information, again, please let me know, but this was prepared with the 2016 trends. So these are this morning's objective: to identify the purpose of the Act. We'll talk again about, as I said, reasonable accommodations, give you the definition of what the Fair Housing Act defines as a disability, how to recognize the request for reasonable accommodation, and then how do you respond to those requests for reasonable accommodation. The purpose of the Fair Housing Act is to provide for fair housing throughout the United States, and the Texas Fair Housing Act mirrors the Federal Fair Housing Act, so we are substantially equivalent to the Federal Fair Housing Act. So we provide in our act for the fair housing practices in the state of Texas, also creates a procedure for investigating and settling complaints, and then lastly provide rights and remedies that are substantially equivalent to what the Federal Fair Housing Act provides as well. So what are the protected classes? These are the federally protected classes. There are more in just different jurisdictions. So the City of Austin, City of San Antonio, Fort Worth, Dallas have local ordinances, but these are the only federally protected classes. And they are race, color, national origin, familial status, religion, sex, and disability. Disability in the Act is labeled handicap, However, most offices will relate it or state that it's disability. So how is disability defined? Under the Fair Housing Act, any person who has a physical or mental impairment that substantially limits one or more major life activities either has a record of an impairment or is regarded as having an impairment is considered disabled under the Fair Housing Act. These are some of the examples of what impairments may be a result of a disability. As you see, what's listed: visual, speech and hearing, cerebral palsy. These are, again, things that are examples of impairment that may result in a disability. Okay. Notice I do want to call your attention to alcoholism and drug addiction. So anything other than a current illegal use of a controlled substance. So for a person who is can be considered disabled if they are a former user, meaning that they're not currently using any illegal drugs. However, with alcoholism, that is considered a disability. So that's one of the things that is considered different as far as drug addiction. And these are some of the major life activities that are impaired: seeing, hearing, breathing, walking. Anything that you cannot do to live on your own is considered a major life activity. I do want to note the difference between ADA and fair housing. A lot of times when we get complaints in our office, complainants and respondents, housing providers, will tell us that we don't have to do this because ADA doesn't require it. Well, ADA may not require it, but the Fair Housing Act may. So the two are not synonymous. The American with Disabilities Act covers service dogs in areas of public accommodation. So that will be places where business is conducted. So your office, a leasing office, a restaurant. The Fair Housing Act, however, covers the sale or rental of housing and those accommodations and modifications that you may make, such as allowing for an emotional support animal. So emotional support animal is covered under the Fair Housing Act. There is no such thing as an emotional support animal under the American with Disabilities Act. So the two are not synonymous. So what are assistance animals under the Fair Housing Act? They include service animals and they include emotional support animals. Service animals are specifically trained to perform a service, such as a seeing eye dog or an animal trained to detect the onset of an epileptic seizure, and then also covers emotional support animals, which provides support for someone with a mental disability. So under the Fair Housing Act, when someone says they are requesting an assistance animal, it can be either a service animal or an emotional support animal. There is no distinction under the Fair Housing Act. So this is what the Fair Housing Act requires, either the federal and the state acts. They require housing providers to make reasonable accommodations to any rules, policies, practices, or services when those accommodations may be necessary to afford persons with disabilities an equal opportunity to use and enjoy their dwelling. So essentially, the housing providers are required when it is feasible, and we'll talk about that, when a complaint or when a tenant comes and requests a reasonable accommodation because of their disability. So if that's the may be necessary, there has to be a connection between the requested accommodation and the disability. We oftentimes get cases in our office where someone will request a first floor unit, but they have a mental disability. Well, it's okay for the housing provider to ask, what is the connection between your mental disability and your request for a first floor unit? Again, there has to be a connection. So just because there's a disability and there's a request doesn't necessarily mean that it has to be granted. A reasonable accommodation is any communication, so it can be written or oral, that requests that you make an exception to the rules, policies, practices, or services, again, that are necessary to afford the person an equal opportunity to use and enjoy the dwelling. This is, again, such as granting an assistance animal. So it can be any type of communication from, I want to say the complainant, but from the tenant or the resident that requests the housing provider to make an exception. These are some of the guidelines that our office uses under the Fair Housing Act to determine whether or not a reasonable accommodation request there was a request. We will ask whether or not they made the request, obviously. It could be oral. It can also be written, but do remember the request does not have to be made in writing or on a certain form. A lot of housing providers will, once a complaint is filed, come in as a defense to the complaint, state that the complainant did not want to complete their form. There is no requirement that it has to be in writing. Obviously, it's better for our office or if there is an investigation, but the law doesn't require it. So one of the things that our office does, not advise but encourage, is if you have someone who is insistent that they don't want to write it down, have a leasing agent to write it and initial it. And if they, this is acknowledging that that they've made the request. So just making certain that you are not requiring the tenant or the applicant to put the request in writing. And so an individual making an accommodation does not need to mention the word reasonable accommodation or anything under the Fair Housing Act. So there aren't any magic words. Just, I need to move to a downstairs floor because I have a disability, or I need to move, I need a service animal, something that alerts a reasonable person that there was a request made. However, again, there aren't any magic words. And then it doesn't have to be made by the person. So a family member can make it, or someone who's making the request on behalf of the person who's disabled. So either the person needing it can request it, someone can make it on their behalf, or obviously a family member. This is what you should do when you receive a reasonable accommodation request. I can provide you all with the HUD DOJ memorandum on reasonable accommodations as a follow-up document. That's the documentation that our office uses as guidance. It's not law, but it does have examples and best practices of what to do when you receive a reasonable accommodation request. Obviously, accepting verbal requests, engage in the interactive process with the person who's making the request. And the interactive process is essentially not telling them no. If someone is asking for something immediately, a best practice our office states is, whether you know that you can do it or not, even if you need to look into how they are disabled, acknowledge the request and let them know that you will get back with them. A lot of times, again, in our office, what happens is someone will request a parking space, and they will say that the housing provider, took 6 months to respond. Well, obviously, it doesn't take 6 months to respond and or make a parking space, but a lot of times it's just a lack of communication. So that is what the interactive process is. You want to make sure that you are continuing conversation with the complainant. If it's a part that needs to be ordered, if it's, paint that needs to be ordered for parking spaces, or whatever it is, making sure that you are, engaging or not leaving the requester in the dark is the best way I would say it. Excuse me. If the disability is not obvious, you can ask for appropriate, reliable disability-related information. We'll talk about that as well. Excuse me. And then providing prompt responses. That goes back to the interactive process. For properties, I think everyone has a different definition of what is prompt. Unless the property receives TDHJ funds, they've given a guidelines of responding in 14 days. I think that's generally a good rule, but you want to make sure that you are, again, interacting with whomever has made the request so that they do understand that you are either working on it or looking for a response. And then document whatever it is that you do. Document your actions because, again, not that you're documenting them for an investigation, but what happens when there is an investigation, it helps an investigator to know what steps you've made after you receive the request. These are things that you should not do after receiving a request for a reasonable accommodation. You may not normally ask the nature and severity of an individual's disability, and then if someone is asking or if an applicant has a disability, you can't ask whether or not they do or if someone that lives with them has a disability. There is an exception if your home only houses people who are disabled. So if someone has to meet the criteria of being disabled to live in a certain type of housing, you can ask about the disability. Otherwise, those questions, you definitely should leave those alone. So I'm going to talk about 3 scenarios about information, about ways that you can ask for information when you receive a reasonable accommodation request. So when the disability and the disability-related need is apparent, you may not ask any additional questions or request further verification. The best example that I can give for this is someone who is blind and making a reasonable accommodation for a seeing eye dog as a request to the no pets policy. The disability and the need is apparent, so there is no need to ask any additional questions regarding why the requester would need a seeing eye dog. The second type of scenario is when the disability is apparent, but the disability-related need is not apparent. You may only ask for verification of the disability-related need, not the verification of the disability. I go back to the blind person as an example. If you have someone who is a tenant who is blind and who is requesting an extra parking space, let's just say that you all do not have, the housing complex does not have assigned parking. So if someone is blind and they are requesting an assigned parking space, you may think, well, why would they need a parking space? Well, you can request information from the resident, the applicant, or whomever, the need for the parking space. And this actually comes from a case that our office had where the lady needed an extra parking space to let her, I want to word this politely, to let her service animal relieve itself. So when she knew where she could go to this particular parking space and clean up after her service animal, as opposed to being in the grass where they had a dog park. Well, the doctor, her medical provider, stated clearly why the parking space was needed. The housing provider, even though the complainant felt that the housing provider should not have requested the information, it wasn't apparent why she needed the parking space, and she did not want to tell them. So in this instance, it was okay for them to ask for the verification of why you need the parking space. And obviously, after it was provided by the medical provider, it was granted. This would be an instance where they could ask for verification of the need for the accommodation, but not verification of a disability because the disability was apparent. And then the last type of scenario that we have is when a disability is not apparent and the need is not apparent. And this is the bulk of our cases, specifically when it comes to mental disabilities. In this instance, you may ask for verification of the disability and the disability-related need for the accommodation. And this really, any example for mental disabilities could fall into this category. Because most oftentimes, if it's a mental disability, the disability is not apparent, and whatever they're requesting may not be apparent as well. So in these instances, the law does say that you can ask for verification of both. Does everyone understand the distinction between the three? Hopefully so.
And I'll go ahead and ask a question if now is appropriate. And you may be getting to this later, but in our online age, where a housing provider or a leasing agent or a property manager may not actually be seeing or working with the applicant or the individual in person, since there are restrictions on what you can ask and when you can ask, what do you recommend is the best practice for a housing provider when, you know, you've got someone who is requesting a reasonable accommodation, but you aren't able to really see whether that disability is obvious or the need is obvious?
Well, that's a really good question. So I would use the third scenario and to document that, because so I'll answer from the investigator standpoint. First of all, if I'm looking at a complaint that someone has said that I've requested this reasonable accommodation, and I've never met the leasing agent, that to me, that to an investigator is going to at the very least indicate that they have no way of knowing you're disabled if they've never seen you. So what I would do as the housing provider, a best practice is to make sure, again, that you documented your actions, the request, when the request came in, and ask for the verification. So it's okay to ask for it if, again, I know that we are doing a lot of things are done online. So not being in the presence of an applicant, if you're not doing some type of Skype or FaceTime, it is okay to ask for that verification of the disability and why that person needs it. And one of the things that I think is important to note, that if a person has a true disability and a true need for an accommodation, none of those are hurdles for them. It's not an issue. It becomes an issue in my mind when they're trying to take advantage of a reasonable accommodation. So if you are truly disabled and truly need whatever it is that you're requesting, I know that you haven't seen me. So I know that it's, I can go to my doctor or medical provider or whomever to request, and it's a reliable third party to get information that's verifiable that I need whatever this accommodation is. So I don't know if that perfectly answers your question, but I would use it. I would start from asking for verification for both the disability and the need, and then just documenting that the listing agent, has never seen the complainant, or I shouldn't say complainant, the resident, and that most transactions are conducted online. And once we've received the verification, we move from there. And usually what happens is once you ask for verification, you get pushback from the resident. And I think that pushback is that they know they don't need it, but that's just, I guess this is what happened.
Gotcha. Okay, thank you.
Okay.
Yeah, that's perfect. Thank you.
Mm-hmm. So this is a what would you do? This is something for you all to think about what you would do in this instance. A rental applicant who uses a wheelchair advises a housing provider that she wishes to keep an assistance dog in her unit, even though the provider has a no pets policy. The applicant's disability is apparent, but the need for the assistance animal is not obvious. What may the housing provider ask the applicant, if anything, to provide? And this is anyone can respond. So in this instance, is everyone clear on what the housing provider can ask the applicant to provide since the disability is obvious, but the need for the assistance animal is not?
Yeah, I'm not getting any questions over on my end.
Okay, great. Okay, so awesome. So the housing provider can ask for the information as to why the disability-related need or the disability-related need for the assistance animal. We also get issues or questions about whether or not a housing provider can deny a reasonable accommodation request. And the answer is yes. If a housing provider has reliable objective evidence that a person with a disability poses a threat to others, that reasonable accommodation request can be denied. And this includes a service animal. So a lot of times I know that we get issues with, well, we can't allow service animals as pit bulls. Well, the law doesn't say that there's a restriction on service animals. However, if the applicant of the resident is there at the property, they have to follow the same rules as other residents with animals. So if their service animal, is aggressive or is, we've had instances where service animals that weren't necessarily pit bulls, but they were claimed to have been service animals, but injured other pets. So those types of instances, and you don't have to wait until the service animal obviously injures a person or pet, or the person does. But if they pose a direct threat to others, it's not a reasonable accommodation request that you have to grant. And then if there's no disability-related need for the accommodation, if there's no disability, you don't need to grant it. A lot of times we get people who will request transfers under the guise of it being a request for reasonable accommodation. It doesn't necessarily mean that you have to grant it. And then if providing the accommodation is just not reasonable, so what our office uses as the test for reasonableness is if it will pose an undue financial and administrative burden, or it would fundamentally alter the nature of the provider's operations. The best example that I have about fundamentally altering the nature of the provider's operations is someone may say, I need a reasonable accommodation to have my trash picked up. And that's not what the apartment complex does. You lease apartments. You're not in the business of picking up residents' trash unless that's what your business is. So that could be a reasonable accommodation that could be denied. And then if it's not reasonable, one of the things that our office strongly encourages is to, again, in the interactive process, discuss alternatives. So you want to, again, not just give them a blanket, no, you can't have X, Y, or Z, but let's discuss A, B, and C, so that the person that is requesting doesn't feel that you just denied their request. This is usually for properties who, with reasonable accommodations, it depends on who's paying. If the property is receiving any type of funds from the government, and there's a reasonable accommodation request, most oftentimes when thinking about parking spaces, the housing provider will pay for it. They may claim, however, an undue financial and administrative burden. If not, then again, the housing provider is responsible for paying for the reasonable accommodation. The good thing about assistance animals, usually there isn't any cost associated with having an assistance animal at the unit. This is another example. I want to talk about what a person would do. This person has a hearing impairment and needs to keep an assistance animal in his unit as a reasonable accommodation. The housing provider may not require the applicant to pay a fee or a security deposit as a condition to keep the assistance animal. However, if the tenant's assistance animal causes damage to either the unit or the common areas, the housing provider may charge the tenant for that cost, if it is the provider's practice to assess tenants for any damage they cause to the premises. And this is an accurate assessment of what should be done. So if there is an assistance animal at the property, while you can't charge an additional fee, and we do have housing providers who push back on this issue as well, but what I try to explain to them is, imagine that an assistance animal is the same as a person who's in a wheelchair. You wouldn't charge a person in a wheelchair additional monies for having a wheelchair. However, it's probable that wheelchair is going to cause some damage in that unit. You treat the two the same. The damage in the unit from the wheelchair, even though the damage from the assistance animal may be greater, you wouldn't charge that person, and so you would assess those fees or fines once they've moved out, or assess them if it's a common area, penalties for whatever, whatever the damages are in the common areas. But you can't charge just like a pet fee or pet rent, pet security deposit if it is an assistance animal. We do have a lot of cases in our office that come from testing agencies, and this is just not to scare you, but for you to be mindful that testing agencies, organizations are constantly calling housing providers, asking questions specifically about pets' weights and breeds. So what they'll normally do is they will look up a property and see that there's a breed restriction or a weight restriction, and they'll call that property under the guise of, I have an emotional support animal. If your breed restriction and weight restriction is 20 pounds, then my emotional support animal is 25 pounds. They will record the conversations, obviously, and a lot of times the housing provider will tell them, we have a breed and weight restriction, we can't allow the service animal. Well, that's not the right thing to say. So what, again, I encourage those who get phone calls about properties is you want to engage that person, let them know that you will either call them back if you're not sure, but for breed and weight restrictions, they do not apply to emotional support animals. So then in this instance, a tester contacted a school by phone, and the tester identified that his son required an emotional support animal. The college representative in this instance would not waive the college's pet rules because pets were not allowed, stated that the ESA would be required to remain indoors, only in the unit, could not, inside the unit, could not go with the college student to cafeteria, those types of places. They also indicated that the students with emotional support animals were encouraged to stay in a specific dormitory. So this was an instance, a case that we had that it was a refusal for a reasonable accommodation and steering. So they had all of the residents who were disabled in a certain dorm, and also would not waive any of the pet rules for the tester service animal. These are the types of calls that lead to complaints in our office.
I've got a question for you.
Yes.
We've been getting actually several questions about this, and wondered, and maybe you'll be talking about this at a later point, but wondered if you could kind of touch on insurance policy restrictions. If a homeowner's insurance policy has a restriction as to breed or certain issues with an animal, how is that handled, or how would y'all look on that if the insurance is saying, no, you can't have a pit bull, or you can't have an animal that's this particular size in the property, or you'll lose your insurance, or there'll be a higher premium or something like that?
So that is a good question, and we do have had instances where insurance companies will not renew policies for breed restrictions. In those instances, there's a memo from HUD as well on insurance restrictions. Those cases we do waive to HUD because they investigate those complaints with the Department of Justice. And the reason is that if an insurance company is informing a homeowner and or renter that they cannot have a specific breed, specifically when it comes to a person being disabled, that is still a violation of the Fair Housing Act. It is, and then that's something, again, that our office doesn't handle internally. That is something, again, that the Department of Justice handles with the insurance company. So it'll be the Department of Justice filing a complaint against ABC Insurance Company. But that's a really good question, and we have had cases. We have 2 cases that have come into our office. We've had to waive them back to HUD. We haven't really followed them as closely because we do know that HUD and the Department of Justice handle those complaints, but we do get those issues or have received those issues in the past. I think it's just a sticky situation to be in for someone to not to feel like they can't have whatever it is because their insurance is telling them that they can't. But unfortunately, if it does come to our office, we do have to refer those to the Department of Justice.
Gotcha. So it's possible that while the housing provider, the landlord, may be able to say, I can't do this because of the insurance policy restriction, the insurance company could be on the hook under the Fair Housing Act.
Correct. And so that is the perfect response. Because what happens in this instance is the complaint was filed against the homeowner and the insurance company. And after interviewing, we did some preliminary investigation. After interviewing the homeowner, it was evident that she provided documentation through correspondence that, hey, my hands are tied. So it's not my decision. My homeowner's insurance said that they will cancel me if I allowed the breed. So it was amended to remove the homeowner. And again, yes, so just for the insurance company, but it's a possibility if the homeowner had said that I'm just flat out denying it, that she would have been on the hook as well. But in this instance, there was documentation that showed that she specifically told the renter, I can't because the insurance company is telling me that they are, and they actually, and the insurance company did non-renew her policy. So it wasn't an instance where the Department of Justice is investigating that company, that agency.
Gotcha. So in that situation, important, document.
Absolutely. It is. It really is. I mean, and that sounds so cliche-ish, and you don't think you're going to ever have a complaint filed against you, and so nobody does, hopefully. But that is so important. If it's sticky notes or Outlook note, whatever it is, if you have an interaction with a resident, an applicant, and especially when it relates to disability, because it's almost like that's on HUD's radar, that for housing providers that, unknowingly or knowingly or however they respond to requests for reasonable accommodations, it's let's go get them. And it's really interesting that there are housing providers whose records are just so poorly kept. And I understand a lot of things are verbal. A lot of times housing providers have relationships with their residents so they can, hey, I saw her in the parking lot. I told her I would do it. And I totally understand that, but I really can't stress enough that it is so important to document your actions, specifically when you're dealing with residents who have some type of disability, because what usually happens, and this is not the case all the time, but what usually happens is if there is the first time that I'm upset that you didn't do something is when I'm going to file a complaint. So we could have been great all this time, and then when something happens, then I want someone to come and rectify this because you didn't do whatever else I wanted you to do. So, yes, documentation is so important.
Gotcha. And I do have a few questions on the same topic. I'm not sure, again, if this is the appropriate time.
This is fine.
The questions involve reliable documentation and what is considered reliable documentation.
That's a really good question.
Yeah, so sometimes we hear from members, an applicant or a tenant presents a certificate that they downloaded online, they paid, $60 for it,
right.
Or that they have a letter from, perhaps a doctor or a health provider who has never seen them or met with them. How do you all view that in terms of that reliable documentation if in fact the disability and the need isn't obvious?
So that's a very good question, and I say that because we have so many cases where people have gone, I think it's called telemedicine, if that's even a word for it, where they've sat in front of a computer and they've in Texas, and they Skyped or FaceTime a doctor in New Jersey and said I needed an emotional support animal, and $49.99 later, they have a certificate. And it makes it, again, really, really difficult for those who need the type of assistance that they're requesting. So, again, there's nothing wrong with requesting if it falls under one of those scenarios where you need the documentation. It doesn't have to come from a medical provider, so it could be it's any reliable third party, and it can even come from the person. So award letters from Social Security, peer groups if a person is in some type of Alcoholics Anonymous, anything that would substantiate that there is a need for the disability-related accommodation. That service animals, assistance animals do not have to have certificates. So certificates, in our opinion, are really not worth the paper that they're printed on, because for emotional support animals, they don't have to be trained. But again, it's okay if you need to verify the source of the documentation to get that information through the requester. So if someone provides you with a certificate and nothing else, you can give that. You can give the requester either a letter, notification, verbally. I need something from your doctor. I need something from your doctor specifically why you need X, Y, or Z. It gets really difficult without seeing each letter. Because anyone could put something on letterhead as well. You can probably pay for that as well online. It's just questionable when it's out of state. When it's something that if you're asking for a reasonable accommodation, we're in Austin, but your doctor is in El Paso, it's questionable. It's questionable. So those types of things, again, can be questioned, and it falls back, again, I think, on the requester. If it's a true need, they won't give any pushback because I'm going to give you whatever you need so that I can get this accommodation granted. If it's, I don't need it, but I want it, I don't want to pay a pet fee, then I'm going to push back. Why do you need this? This letter is legit. This is, I'm going to give you all these runarounds. So it does make it difficult for the housing provider. It makes it extremely difficult for us as investigators. But if you ever have a question about the reliability of a letter or documentation that you've received, call our office. Call, and you can talk to any investigator. You can talk to any supervisor, any housing manager, send it over, let us review it. And so we're not in the position to provide advice on something, but we can say, hey, this looks like if they were presenting this with this information, this should be sufficient, or it shouldn't be sufficient. Again, it's just the blanket is that, or I should say the overarching response is, if it's a true need, they will not give you any pushback, and they won't have a certificate of anything because there's no need for that. There's no need for any of that if you are just requesting an emotional support animal. So, but that's a good question, and unfortunately, that's something that we have to deal with most of our reasonable accommodations. We have letters from doctors in New York or letters from doctors who only have P.O. boxes, don't have it. So it makes it difficult. It really does.
Gotcha. Okay, thank you.
Mm-hmm. This is another instance of a respondent manager asking for a pet deposit. As I said before, pet deposits, pet rent, any of those things for emotional support animals you cannot request. This particular complainant stated that she was refused a reasonable accommodation because of her disability, and in this instance, she was, because the managers wanted to charge her for a pet, and it was her emotional support animal. This is one of the things that you can do, as you're doing now, is to get educated, know what the law is and what your responsibilities are. Then, as I said it before, you want to make sure that you're documenting everything that you do. Document every action, document. It is okay, as I said, to contact our office if you have any questions. If you have any specific questions about anything that arises that seems, I'm not really sure if I should do this, I'm not really sure how I should respond. Again, making sure that you're in that interactive process. If you have to tell a resident, let me get back with you, let me talk to management, let me talk to corporate, whatever it is, to let them know, again, that you're not delaying your response, because an undue delay is also considered a denial when it comes to reasonable accommodation. And so that's why it's important to document what you've done and to engage in the interactive process, because what will happen is if someone files a complaint, at least we can see that you all have been engaging, you have been talking to the person since they made the request. And this is the same thing that we tell housing consumers. Well, we don't want them to file fair housing complaints, but if they've educated themselves and they feel that they're being discriminated against, they have that right. And you can do everything right and still have someone file a complaint against you. So that I say it because the threshold is just so low for filing a complaint. You can just get them filed against you. It doesn't necessarily mean that you've done something wrong, but just know that there are people who use and abuse the system in the wrong and the right way. And so it doesn't absolve you from having a complaint filed just because you've done the right thing throughout the way. So that's why, again, it's just important to make sure that you've documented everything. This is what happens when a complaint is filed in our office. This is what happens if you have a complaint filed against you. We will notify the respondent of the allegations, and we do invite everyone to mediate. And mediation, as I'll talk about in a second, is just a quicker, easier way to resolve complaints. That is another way for a case to be resolved. This is just our process of how we investigate complaints. We determine if the person has a disability, and then whether or not the housing provider knew or should have known. And that's where the online gets a little tricky sometimes. And that's why, again, it's really good to document, because if there's no way that you could have known the person had a disability, then there was no way that you could have denied a reasonable accommodation because you did not know about a disability. And then was there a request? So you have to have a request. Just because you know that someone is disabled doesn't mean that you have to automatically assume that they want a reasonable accommodation. And we also obviously ask or investigate or analyze whether or not it was a refusal. So you have to, these are the steps that we go through on each case when we get a reasonable accommodation request for any type of assistance animal, parking space, to analyze whether or not there was a violation. This is just our mediation process. Again, it's a free service. It's offered at the time that a complainant files the complaint, and they can choose, if both parties don't agree at the beginning, they can choose up until the time there is a resolution of the investigation. Obviously, it's faster than litigation, easier than an investigation, so it's the fastest way to resolve a complaint. Saves time and money on both sides. And a lot of times what we find is that parties just want to speak to one another. So this is a way of opening those lines of communication. And then it's a binding agreement. So once you've signed the mediation or conciliation agreement, then it is resolved and both parties are bound by whatever is in that agreement. These are, as I said, some of the trends that we've had in 2016. As you can see, this doesn't change much. Most of our cases come because of disability-related claims, 77% of them, and the numbers are the same or similar every year. And as you can see, the bulk of our cases of the terms and conditions for reasonable accommodation. So that's something that we get in our office quite often. I'll leave this up. And I can email this link for the Civil Rights Reporter. That's a quarterly report that comes out from our office that has updates on fair housing cases. So if you want to subscribe to that, I can also email this link to Abby for distribution as well. Are there any other questions about anything that I didn't talk about that you want to ask or that you want me to expound on?
There are, and there are several that are similar, so I'm going to try to kind of group these questions together.
Okay.
But, one of the questions here is, people are talking about scenarios where a request for, let's say, an emotional support animal was never made, but the landlord finds out, let's say, halfway through the lease that they have an animal on the property, and that's when the request comes in. How would you recommend a landlord handle that, or what is the best practice?
So one of the things, so first of all, that's very common. Most oftentimes, emotional support animals are not found until a maintenance request comes or some maintenance person comes and sees that there's a pet in the house, in the unit. It is still considered a pet until you have documentation of otherwise. So at the moment that you find out that the pet is there, so let's just say that there is a lease violation on day 1, the complainant comes to you on day 3, hey, or day 2, this is my emotional support animal, I will get the documentation to you. Until that documentation is provided to you, it's still a pet. you may want to, again, keep the lines of communication open. Definitely want to document, how it was found, when it was found, because a lot of times what our office will do is we will look at the application to see if there was any indication that the resident or the applicant is disabled. We will ask for the lease file, so if there's any award, anything that would make the landlord, a housing provider, know or imply that the person was disabled. And obviously, usually there isn't that information. So again, that's why it's always good to document that, this is when the person was found to have an animal. This is when the lease violation was issued. This is when the request for documentation was requested. Up until this time, our office has not received anything. So those are perfect cases where you want to make sure that you're documenting, because they are probably going to, if they get enough information to think I can file a complaint, want to file a complaint because they were in the wrong. They were in the wrong and they don't want to pay the pet fee. That's usually what it is. But until you get that documentation, it's still considered a pet.
Gotcha. So here's a couple questions, and I suspect you'll answer this similarly to how you answered the insurance policy restriction. But what if an HOA has a breed restriction, or what if a city has a breed restriction? Is that kind of the same concept as the insurance company issue?
Right, it is. And so you do have cities and HOAs that have breed restrictions. Again, there should be an exception for service animals. And if not, that is our office can take complaints against it, as long as the city is not the city of Austin, but can take complaints against cities and obviously HOAs that have breed and weight restrictions, because again, service animals are not pets, and so there should always be an exception to that policy, and that's what a reasonable accommodation is. I'm asking for an exception to the no pets policy, to the breed, to the weight restriction, because of my disability. So in those instances where it is a city or an HOA, right, the response is similar. Our office will investigate those complaints against those cities and or HOA if they're in violation because of a service animal, obviously not the pet.
Right, gotcha. Okay. And then a question here about multiple animals. If an applicant, if a tenant, someone is requesting or requesting a reasonable accommodation for multiple service animals or emotional support animals, is it kind of the same analysis?
Well, so it depends on the documentation. So if there are multiple support animals, if you're talking about for one resident, I'm just going to make the assumption it's for one resident. So obviously, if you have multiple people in a home who are disabled, each one can have their own service animal or assistant animal. But if it's one person and we actually had a case that was in a rural area where a young lady had chickens as an assistance animal, and she had seven. She had 7 chickens as assistance animal as her emotional support animals, and there was a doctor's note that she needed those 7, but there was a conciliation. What happened in this instance is they were in violation, I think, of the HOA rules. But what happened is there was an agreement that once they, I don't want to use the word died off, but I think that's kind of how it was, that once they died off, that she would not get any more. So whatever she had, she would keep. So as long as there is reliable documentation that she needed or the applicant needs several, whatever that multiple number is, so if it's 3 of whatever, there has to be documentation for each. And usually one person doesn't have more than one. I mean, they can, but we don't get that often. The case of the chickens was definitely an anomaly in our office. But there was documentation that supported that she needed those. So unless you have documentation from a reliable third party that person or the applicant needs 3 of whatever, then the extra pets are considered just that. They're considered pets unless you get documentation to state otherwise.
Gotcha. And kind of in that same line, we've been getting some questions about, what exactly can be an emotional support animal, and it's really any animal, isn't it?
That's a really good question. So any animal. So we've had a miniature horse, we've had a lemur, we've had a parrot, cats, we've had rabbits. I mean, it can be literally anything. And so we had a case where there was an emotional support animal as a turtle. So it's just, again, it's specific for the tenant of the applicant or that person, and whatever comfort that particular animal provides. I'm not an animal person, so I just don't get it at all. But whatever comfort that animal provides to the person, and it's almost as if, I can't tell you when you're cold. That's something that is subjective. So when you're cold, I can't tell you. So whatever service that they provide, it can be so many things, and that's why, again, if it's needed, if it's a true disability and it's a reasonable accommodation request, that's why there usually isn't any pushback. There is a need for this. The doctor has been seeing this person for whatever mental disability they have. They can corroborate that, and it's legitimate. That's why it's not you don't find them when you're doing an inspection. You don't just walk in on a routine maintenance repair request and find that they're there. It's a true need for it, and they know that. It's not I didn't know if I should tell someone. That's why those cases are just so questionable, because a lot of times if you have multiples or if you have them hidden in the unit, it's a pet. It's not a service animal, but service animals can be, literally can be anything.
Right.
Or any type, I should say.
I think we have time for maybe one more question.
Absolutely.
There's several more questions here, but I want to honor your time. So just one more question. We're getting a lot of questions about, what is considered reliable documentation, and I know you talked about that earlier. But if you wouldn't mind kind of going over again, it's from a health provider,
sure.
mental health provider, that kind of thing.
Sure. So reliable documentation could be anything. It's a reliable third party unless it's documentation that the requester has, like I said, a disability award letter. But it can be from a peer support group. It could be from a it could be from a caseworker. So someone who has knowledge of the disability and the need for the disability-related accommodation. So if someone is attending, I'm going to use, again, Alcoholics Anonymous, the case manager, caseworker there knows that this person needs a turtle, know that this person needs a turtle so that he won't drink. We actually have a case in our office now where there is a person who does suffer from alcoholism, and he has a cow. Obviously, he lives in the country, but he has a cow, and so that's his emotional support animal. And his doctor knows that when the cow is not near, he tends to drink. But there is documentation to support that. So, even though usually it does come from a doctor because you're seeing a doctor, but it could be a therapist. We've had marriage counselors who attested to someone having a disability. So I think the focus shouldn't necessarily be on where the letter comes. I mean, it needs to be reliable, of course, but not necessarily where it comes from, because any reliable third person could know about the person's disability. But you want to make sure that the focus of who it is, of what it is, is that there's a disability and there's a need for the accommodation. You obviously want to make sure that it's someone that they've been seeing, not just the telemedicine. That's another red flag. If there were a such thing as red flags in our office, you just don't want to be. You just don't want to approve accommodations because someone is trying, again, not to pay a pet deposit or a pet fee.
Gotcha.
And that's understandable.
Right. Well, thank you so much, Chalisa. That was great information. For our audience, just as a reminder, we have recorded this webinar, and the recording will be available in the follow-up email you'll receive after the conclusion today, and then will also be available on our website, texasrealestate.com. So thank you again, Chalisa. That was great information, and thank you everyone for joining us today.
Thank you.
Thanks.
Okay, bye-bye.